Hello and welcome. Thanks so much for joining us today as we talk through the first of our three-part estate planning series. Our first part is the basics of estate planning. Second part will be trusts and more complex estate planning. And our third part will be charitable vehicles and the different avenues of charitable giving. My name is Julie Westbrock. I work for TrustPoint Inc. We are a trust and investment management services company. We act as a professional fiduciary, such as trustee. Joining me today is Lauren Fink. She is an attorney with the law firm of Amundson, Boggio, and she specializes in elder law and estate planning. Lauren and I are on the advisory board of the Minnesota and Dakota's chapter of the Parkinson's Foundation. Thank you so much for joining me today, Lauren, as we talk about the basics of estate planning.
Thanks for having me.
So, Lauren, statistics tell us that only 37% of Americans have a will, which I feel like is not surprising because 74% of Americans happen to find estate planning confusing. So tell me, at a bare bones minimum, what documents do you think everyone should have?
Sure. So I think that not only do a lot of people not do estate planning, but a lot of people think that maybe estate planning wouldn't be appropriate for them. But anybody who is over the age of 18 should, even at a bare minimum, have a power of attorney or a healthcare directive or a will. Powers of attorney and healthcare directives are documents that help you in the event that you are either physically or mentally incapacitated and you're not able to make financial, property, or healthcare decisions. They allow someone else to step into your shoes and either manage your assets, your property, or make healthcare decisions when you're not able to do that.
Let's talk first about the healthcare directive. Tell me, why is this document so important?
Sure. So the healthcare directive nominates someone to make healthcare decisions on your behalf. And in addition to nominating an agent, many times healthcare directives contain information about what your wishes are for how you want to receive medical care. So without a healthcare directive, if you are incapacitated and you're not able to indicate what your medical wishes are, then the default is that you have to go through a legal proceeding called a guardianship in order to have someone appointed by a court to be able to make healthcare decisions for you. When we talk about healthcare directives, I like to bring up the Terry Schiavo or the Karen Quillen cases a lot. Which were cases that a lot of people are familiar with that happened in the 90s when women who were actually pretty young, both Karen Quillen and Terry Schiavo were in their 30s, when they had different accidents that they went through that put them where they were on life support treatment, but they didn't have capacity, they couldn't make their decisions. And neither one of them had executed healthcare directives. And the only reason that we know who these women are and what their names are is because they didn't have healthcare directives, and then their families got into really big fights about the decision to withdraw life support for those two women. So that's why it's really important to have a healthcare directive, not only to say, here's a person that is going to make this decision for me, but also to say, if I get put into a position where I'm receiving life support treatment or some type of terminal condition supports, I don't want heroic measures, or I do want heroic measures, or here's what I want my healthcare agent to decide for me.
Okay, and who can be a healthcare agent, and how would one go about choosing the right person?
Sure. So you can pick anybody that you would like to be your healthcare agent. Generally, people pick family members or friends. There are even people who can act as a professional fiduciary and make healthcare decisions for someone else. Typically, we see people pick their spouse or their children, depending on their circumstances. But the really important thing about choosing a healthcare agent is choosing the person who is going to be able to make decisions that are in line with what your decisions are, because we can't always, we don't always agree on what type of medical treatments we're going to want to receive and what ones we're not going to want to receive. And just someone that's going to be able to make big decisions, such as terminating life support. That may be a decision that your healthcare agent is confronted with someday. And is the person that you've chosen going to be brave enough to be able to make the decision that you want them to make if they're asked that question?
Okay. So it sounds like it should be obviously somebody you trust, but somebody you would also need to communicate those wishes with so that they're not in the dark if something were to happen.
Yes, it's not only about appointing the right person, but then it's also about having conversations with that person about what your wishes are. So Barbara Bush, when she was towards the end of her life, was incredibly communicative with not only her family members and the people that she had appointed in her healthcare directive, but with the American public about, this is what I want for my healthcare, is to sort of show everyone that if you don't tell people what you want, then you're going to make their job a lot more difficult, because they're going to have to try to guess what you want them to do in terms of healthcare decisions. So, it's ongoing, having those types of discussions.
Okay. So a healthcare directive is a form that gets filled out. And where does one find a healthcare directive form?
So you can have an attorney prepare a healthcare directive for you. Otherwise, if you have a physicians group, many times they will have healthcare directives available. In Minnesota, the one that you will frequently see is called Honoring Choices. Or sometimes the different doctors groups will have their own version of a Minnesota healthcare directive. There's also a document called the 5 Wishes Healthcare Directive, which is a document that was designed to be good in every state and to meet the execution requirements across the whole nation. It's a pretty comprehensive document, but there are many different ways that you can get those completed and filled out.
Okay, great. Thank you. So moving on to the power of attorney document. Can you talk a little bit about this form and how it works?
Sure. So in Minnesota, you typically see 2 different types of powers of attorney. And again, the power of attorney is the document that allows someone to make financial and property decisions for you. You'll usually see either a statutory short form power of attorney, which is a type of power of attorney that was developed by the Minnesota legislature, and it comes right out of Minnesota statutes. Or you see a common law power of attorney, which would be a type of power of attorney that an attorney would specifically draft for you and put provisions in that document that they think you should have, customize it for your circumstances. The power of attorney picks someone to be your agent, and then it outlines when that document might be effective. So is it effective now from when you sign the document, or is it a springing power of attorney where the person who you've appointed, your attorney in fact, has to obtain a physician's note that you don't have capacity anymore, so now this document is in effect. And then it goes through what powers you would like to delegate to your attorney in fact. So sometimes with powers of attorney, you'll see them done for specific transactions, such as a real estate closure. Sometimes you'll see just specifically for this piece of real estate, this person can make decisions for me. But more often we see them completed fairly broadly, which is all of my different bank accounts that I have, all of my real estate, this person or these persons that I've appointed can make decisions for me.
How does one go about choosing the right person to name as a power of attorney?
Yeah, so Usually you want to pick someone who you would trust. So many times with married couples, you see spouses as initial agents, and you can layer your agents or name them in successive order. So most frequently I see spouse and then children listed as backup agents. Or you can also have a professional fiduciary act as your attorney in fact under a power of attorney. um, you want to be careful to pick someone that you trust. When I talk to clients about who they're choosing for a power of attorney, I like to describe it as this is a person that you're going to hand your checkbook over to. So who would be a good person to do that with, and who wouldn't be not so good of a person to do that with. And if you have a family member who has financial trouble, they can't manage their own money, or they would just be really overwhelmed with having to act as your attorney in fact, and they're probably not a great pick. I like to give examples of if you've got a accountant or a bookkeeper or something like that in your family, that's probably a good one to choose for your attorney in fact, because they're going to be thorough and they're going to keep records of what they're doing and manage your assets and pay your bills on time.
Right, right. So can the healthcare agent and the power of attorney be the same person?
They can be the same person. Sometimes whether they should be the same person is kind of a question. For example, if you have two kids, one child is a doctor and the other child is an accountant, then the doctor is probably going to be the better person to act as the attorney or the healthcare agent, and the accountant is going to be the better one to act as the attorney in fact under the power of attorney. But if you've got one person, they can play both roles. But what you may want to check on too is, are they comfortable acting in that role for you? Sometimes clients will complete powers of attorney or healthcare directives and just put people in that document. And sometimes that person doesn't know that they've been named into that position and may not want to take on that role. And if that's the case, it would be better to know that prior to drafting and executing the document than when we actually have a need for someone to act.
So you mentioned that the power of attorney document is like handing over your checkbook. So talk to me about, when does this document become effective? I know you talked about the springing power, which is not until somebody might become incapacitated. But if I execute a power of attorney now and I make you my power of attorney, what can you do with that?
If I have access to that document, I can take that into your bank and I could take all of the money out of your bank account if I wanted to. And that document is effective from the time that it's signed, if it's an immediate power of attorney, until either the time that you put in that document as an expiration date or until your death. So with that, being aware of what your goal is with the power of attorney, and then matching that goal with the effective date or the duration of the power of attorney is a good thing to do. Typically, my recommendation for clients would be to have an immediate power of attorney, because it can be difficult sometimes to get a doctor to certify someone as incapacitated, especially if that person has dementia. People with dementia can have good days and bad days, and doctors don't always like to say when someone can manage their finances or not. And to have that document be continually in effect makes it so that you don't have to continue to recertify or rehab that document executed, because there may come a day when you don't have the ability to execute a power of attorney depending on your medical condition.
And the power of attorney, when it terminates on death, I think there may be a common misconception that a power of attorney document could be used to pay bills after somebody passes. But if the power of attorney document ends at death, then what are the options for continuing to pay bills?
Sure. It depends on the ownership of the account and what type of estate plan the person has developed up to this point. So, for example, there are a lot of accounts that can pass by non-probate transfer. So probate is the judicial process of passing your assets on to your heirs. Basically, the probate court receives information about your death, and then if you have a will or if you don't have a will, determines who can be the person who is appointed as your personal representative, which would be the person that's in charge of your estate, and where your property would ultimately be distributed. But the only kind of property that goes through probate is property that is held solely in your name, that doesn't have a joint owner, that doesn't have a beneficiary named, and that isn't held inside of a trust. So if you have a joint owner on your account, then that person would automatically take over that account. They provide a copy of the death certificate to the financial institution, and then that account becomes their account. I always like to say it's joint tenancy is last man standing wins, where whoever the last person alive is the one that inherits that property. Beneficiary designations function similarly to jointly held bank accounts, with the exception that the beneficiaries who are named on the accounts don't own that account during your life. They are just the ones that immediately inherit that property on your death. They furnish a death certificate to the financial institution, and then they have the ability to take ownership of that account. So with the question of how can bills be paid after your death, it depends on where those assets would go after your death. If it's by non-probate transfer, then you have to rely that the people that are named as the joint owners or the beneficiaries are going to do their due diligence and make sure that your bills are being paid. Otherwise, those creditors might come forward and start a probate because they want the money that passed by non-probate transfer to come back in and pay their bill. If it's a will, then the creditors can place claims against your estate, and then whomever is appointed by the probate court as your personal representative would pay those claims if they are valid claims.
Great, thank you. So in Minnesota, the state statutes call the person that is administering a probate a personal representative, but there can also be referred to as an executor. Is that correct?
That's right, yes.
Okay. So this is a good segue into discussing the will document. So is it really necessary to have a will for somebody who doesn't have significant assets?
It may not be a document that would be used if that person has beneficiary designations and is passing their property by non-probate transfer. However, if you don't have a will, it means that you haven't made any choices, and the choices are already being made for you by the state of Minnesota. So you in the will are able to basically write a letter to the judge at the probate court to say, "Dear judge, now that I am gone, this is what I want to have happen with my property. This is the person that I would like to be my personal representative and in charge of my estate. And ultimately, this is the order that I want things to be paid in." Even if you don't end up using that will, it's important to be aware that it's still a good idea to execute one, because the defaults that Minnesota sets for you under the what's called the intestacy statutes, which are the statutes that say if you don't have a will, then here's where your stuff is going to go and here's who's going to be in charge of it. The default might not be what you want to have happen.
Okay. And so what if I have minor children?
Especially if you have minor children, it's a really good idea to execute a will, because your will is where you nominate who the person would be that would be appointed the guardian of your child. And that nomination goes as part of the guardianship proceeding that would then result if both you and your spouse are deceased. The other thing that you can do in your will is establish trusts for your children, which if you're passing property on and you have minor children, you're not going to want them to receive that property outright. And you're probably going to want to have some say over how that property is managed for them, what the money's spent for, and who the person is that's going to be in charge of it. If you don't have that, then what happens is that your property passes to your minor children under those intestacy statutes, and a guardianship has to be established with the court system. And in that guardianship, the court chooses who the person would be that would be in charge of your children's decisions. And without a will, you have not given your recommendation for who the person should be. A conservatorship would also be established depending on the amount of assets that were distributed to your child. And in the conservatorship, someone is selected by the court to make financial decisions regarding those funds. And again, there are annual filings that have to happen with the court in both a guardianship and in a conservatorship. And it's a lot more costly to have to go through those types of legal proceedings than if you have planned ahead and indicated in your will where you want the property to go, who you want to manage it, and also who you want to be the guardian of your child.
Okay, so it sounds like if I passed and have minor children, but I don't have a will, that somebody who doesn't know me and doesn't know my children is going to make the decision of who they get to stay with. Is that right?
Potentially, yes.
So with regard to the personal representative, again, along with the healthcare directive and your power of attorney, what kind of person should you name as your personal representative?
So it falls pretty similarly to a person that would be a good power of attorney or attorney in fact under a power of attorney document. The role of a personal representative in a probate is to gather together all of the assets of your estate, identify expenses and costs that need to be paid, creditors, and whether these are valid debts against the estate, pay those creditors, pay taxes, make proper tax elections, and then ultimately distribute all of the assets according to the terms of your will. It takes a lot of time to go through the probate process, and it can be very easy. In Minnesota, we have a simplified, informal, unsupervised probate that can happen where you don't even end up having a hearing with a court. But it depends on the assets in the estate. It still is a lot of work to go through a lifetime of assets and personal belongings and make sure that they end up where they are supposed to go. And to get the taxes filed, you're usually having a personal representative who's acting for at least a year in that estate, whether they're actively doing something the entire time or not. Okay. So an organized person would be who I would suggest.
Right. There is the option of the professional fiduciary.
There also is the option of a professional fiduciary. And then, I've had many clients who have made that election for a professional fiduciary. And when you're deciding whether to use a professional or whether to use a family member, you kind of think about the complexity of your estate and who the people are that you have available to act as a personal representative. And I had a conversation with a client very recently who was a business owner and who had multiple pieces of real estate. And when we were talking about who could be personal representative, she has younger children at this point, and if something were to happen to her, she's not confident that they would be able to successfully manage the winding up of her business and the sale of her real estate. And that's where a professional fiduciary can be really helpful.
Right. So you and I have had mutual clients because TrustPoint, as a professional fiduciary, we are willing to step into the personal representative role. And so I've seen those complex situations where it makes sense for the professional to step in, because we do have a full team of people that can be helping out with that. And I've spoken to many couples and individuals who, if they're single, no children, no family left, and don't want to burden a friend with that, that's where a professional can make sense. Or again, if it's just a really complicated, or family dynamics are complicated as well, that could be an opportunity for a professional fiduciary.
Absolutely. If there's a lot of circumstances where someone who is acting as a personal representative, the other beneficiaries of the estate can get suspicious or concerned or think that they're not doing their job correctly, and it can really tear a family apart. And that's where a professional fiduciary can be really great, because if there's something in the will that is disinheriting someone or restricting someone's access to their inheritance, then rather than blaming the family member who is in charge of carrying out your wishes, they can blame the professional fiduciary and take, that Christmas is no longer a tense gathering, because they're mad at the professional fiduciary rather than you as the personal representative.
Right. They'll have that common goal. So you mentioned the will is where you can designate who you want to get your property. Do they have to be individuals named in there, or could a charity also be named in a will?
You can name whomever you would like in your will. You can name charitable organizations. The great thing about naming charitable organizations is that you get a tax deduction for the money that's contributed to the charity. You don't get an income tax deduction, but you get an estate tax deduction. So depending on the amount of assets that you have, that can be a way to reduce the taxes that you pay in a way that benefits an organization that you believe strongly in and that you want to support. So you can do specific distributions to a charity where you give a bequest off of the top, I've had clients who all of their beneficiaries have been charitable organizations because they had children or family members who had already done really well for themselves. So they were able to give to causes that they believed in.
So Lauren, what resources are available for somebody to create a will?
There are a lot of online resources for establishing a will. Those can be used or can be successful in the event that you have a very simple estate, but more complex estates really should involve an attorney who is familiar not only with your specific goals, but also with the assets that you have that you want to pass on, because the online resources don't always have attorneys reviewing the end product to ensure that it is going to be successful, and that it is going to meet the laws of the state that you live in.
So today we talked about the healthcare directive, the power of attorney, and a will. Is there anything else that you would want to mention regarding these documents?
I think another thing to think about with a healthcare directive, many times people think that a healthcare directive is a do not resuscitate or a do not intubate, or it's a pull the plug document. And there's another document to be aware of if you've been diagnosed with a terminal condition that you should talk to your doctor about. And that document is called a POLST, P-O-L-S-T, which stands for Physician's Orders for Life Support Treatment. And what a POLST document does is it allows a physician's orders to sort of become a standing order for specific types of treatments that you may receive. With a healthcare directive, you could indicate in that document that you don't want any heroic measures. But if you are found unconscious or unresponsive by first responders, they're still going to provide you with life support treatment. And that may not be something that you want, depending on what type of medical condition you have. So for example, for many clients who I work with who are older or who have been diagnosed with advanced dementia, or just a condition where if they were found unresponsive and they were just allowed to die naturally at that point, that would be preferential. A POLST can be a really useful document to enable those wishes and to prevent that person from having to go through some type of traumatic resuscitative treatment.
Great. Well, thank you so much for mentioning that document and for joining me today as we talked about the basics of estate planning. And thanks to all of you for tuning in. I hope that you will join us for part 2 of our series, which will be on trusts and more complicated estates, and also part 3, which will be about charitable vehicles. Thanks so much for joining us.